Hello and welcome to Husch Blackwell's Labor Law Insider Podcast. I'm your host, Tom Godar, and together with my Husch Blackwell colleagues and thought leaders from around the country, we will discuss and explore the ever-changing issues in the world of labor law. President Biden promised to be the most pro-union president ever, and he is fulfilling that promise. The next 4 years promises to be a wild ride, so buckle up and join us on the Labor Law Insider Podcast. Hello and welcome once again to the Labor Law Insider Podcast. It's terrific to have you back, and we're going to have a wonderful time today talking about the way in which the NLRB is changing and therefore essentially asking employers to change their policies. The prediction that we made a year ago plus was that the Biden administration and the new board and general counsel would make a bunch of changes that would indeed change the landscape of how employers and employees would interact with one another. And while that wasn't a hard prediction, we're seeing it play out. And today, through our podcast and then the follow-up podcast, which will air in a couple of weeks, really goes through some of the ways in which those changes are taking place, asking employers to change the way they create policies and enforce them in a number of areas, including, but not limited to, social media. We have today two wonderful guests, and they're new guests to the Labor Law Insider. Tyler Paetkau is joining us, and so is Olga Savage. They're both new to the Labor Law Insider, but new to Husch Blackwell as well. We go way back with Tyler, that is I do, and had the great pleasure of co-trying a case with him out in California many years ago. He is an expert in labor and employment law and indeed recognized as such in the fact that he's been named a super lawyer. And with him and us today is Olga Savage, who is also practicing in the Silicon Valley area. She is a terrific addition to our team out in California with lots of experience in litigation, labor litigation, as well as more traditional employment litigation. And she's also, to a bonus for some of our clients and friends, a native Russian speaker, which occasionally comes in handy as we get involved in our international practice around here at Husch Blackwell. Welcome, both of you. It's so great to have you here.
Thank you so much, Tom. Thank you for having me.
Thanks, Tom.
Well, I look forward to this conversation because, first of all, it makes me look pretty smart because I predicted, well, frankly, my guest predicted long ago that when President Biden was elected, that he would keep his promise to be the most union-friendly president ever, and that would force certain changes, day-to-day changes and practices on companies, both union-free and union-organized, with regard to how they're going to interact with their employees, particularly in the area of how employers are looking at policies and enforcement of policies related to social media. How are we doing on our predictions? I'll start out with you, Tyler. How are we doing on our predictions that the world has changed under the Biden administration as it relates to social media policies?
Well, Tom, your prediction was prescient and not a difficult prediction based on the public comments, both by President Biden and also officials of the NLRB. And they've been fairly unabashed about the agenda here. Those on the podcast will recall that we had a brief respite during the Trump NLRB, a few changes in policy that made it easier for employers, a little more employer-friendly. And since Biden has taken office, there's been really a one-way train to change all of those policies. And in August of 2021, the new general counsel, Jennifer Abruzzo, came out with essentially an agenda for her administration. And they are targeting, among other things, employer handbook rules, confidentiality provisions, including in separation agreements, defining what is protected concerted activity under the Act, union access, jurisdiction over religious institutions, and the number of other initiatives that are in her initial policy memo from August 2021 that have come to fruition in policy memos and now in some ALJ decisions. So the the focus is on reversing a lot of the Trump board rules. I would also add that the NLRB is very political, as we all know, and with the appointment of union side attorney Gwen Wilcox to the board by President Biden, that's really signaled a sharp turn to the left on almost every single policy you can imagine, including what we're going to talk about today here, Section 7 rights under the Act. So you were correct, Tom, in your predictions.
Well, and I give that to my guest. But yeah, it's certainly been interesting for our clients to start to focus on what this might really mean on the day-to-day, on-the-ground stuff. I'm believing that almost everyone that we work with and almost everyone listening to this podcast has a handbook, a set of policies to guide their actions and their interactions with the employees in the workplace. You've talked about these changes. Olga, first of all, has legislation, as opposed to the board activities, really fostered any of these changes, or has it really been through administrative and NLRB appointments that have made those changes?
Well, that's a really good question, Tom, because we, especially out here in California, as you know, we tend to be the front runner in shifts in employment law and shifts that impact employment policies. We are constantly expecting changes in legislation, and primarily state legislation, that prompt changes in company policies. When we're talking, however, about changes on a federal level, the board really does play a really significant role. The board is a somewhat different animal than a lot of other federal agencies and administrative agencies, in that, a lot of other agencies, they'll announce and implement new rules and changes through a notice and comment rulemaking process, whereas the board generally changes rules through adjudication of individual cases, right? So we have a situation where we have a general counsel who in this case is one that is certainly has a tendency to be pro-labor. She's a former special counsel to the Communications Workers of America. So she has the authority to issue recommendations and memoranda flagging certain workplace issues and rules that need to be re-examined. And then that then goes to the advice branch of the board, and the board decides whether to essentially prosecute individual employers for what they deem to be labor violations. And it's those cases that will result in new rules that employers will need to consider, new rules in what is permitted in a social media policy, in workplace conduct policies, in employee discipline for activity that could arguably be deemed pro-union. So yes, the employers will need to be looking very closely here in the upcoming couple of years during this administration as to what kind of cases the board is taking on and how the decisions in those cases will impact their policies and their handbooks and their practices.
And I don't have any private poll numbers, and I've heard various talking heads tell us that the Republicans are going to have a great off-year election, and now I'm hearing, well, maybe not so great, and in fact, maybe it'll go the other way. And so right now, even though we've been fearful of, if that's the right word, concerned about, thoughtful about the possibility of legislative changes through, for instance, the PRO Act, which would be a very union-friendly legislation changing the way in which elections take place and how to count majorities and all that sort of jazz for unions. Right now, until at least the midterm elections changes the balance of power, we're not too much looking at legislative changes on the national level, but these changes that General Counsel Abruzzo and others have fostered. But let me ask you a question. I'll throw this up as a jump ball. Either of you can jump in. You talked a little bit, Tyler, about the change from the Trump administration to the Biden administration. And we look at these pendulum changes. We see that elections have consequences. Are these of a greater scope and nature than historically has been true? Or is this just the same old, same old? Whoever wants to jump in on that one.
Yeah, that's a good question. I mean, my sense is that these are bigger changes happening faster than has been traditionally the case with the board. We in the old days, we might have a policy memorandum put out by the general counsel a couple of times a year. And I'm looking, just in the last 2 years, it seems like we get one every month. and every one is a big deal to employers. They deal with like things that we all have to be cognizant of, workplace rules that come up again and again. The frustrating, I think, for the employer community is most employers are well-intentioned. They want to comply with the law. They just want to know what it is, and don't beat around the bush. Just tell me what I need to do to avoid getting into trouble with the law. And unfortunately, with this pendulum swing, you read a case just from 1 year ago, and you read. I mean, right now I'm thinking about a case called Medic Ambulance Services in January 2021, where the board essentially liberalized the rules on work rules and what is violative of this Section 7 right to protected concerted activity. But then if you flip over another year, not even a year, January 22, we have this Stericycle case. And in that case, we have the dissent in Medical Alert is now the majority. And the majority in Medical Alert is now the dissenters. That's members Kaplan and Ring. And just the contrast between those two, just in the span of 1 year, is kind of mind-boggling to me. And I don't blame employers if they don't know the current rules and where it's going. It certainly looks like this is on the radar, social media policies in particular. I would just, not to be too verbose here, but if you read the dissent in the more recent case, Stericycle, the dissenters point out, I think I'll just read a short passage. Somewhere along the line, however, a board majority saw fit to adopt this dissenting view without bothering to overrule Lutheran heritage. And with that, the board became the Federal Employee Handbook Police, seeking out and scrutinizing employer rules, policies, and handbook provisions for possible violations of the Act. That's what's happened now. The board is going to, the shift is the board is going to look at whether a policy might interfere with Section 7 rights. And there's very little recognition of the reasons for those work rules, the employer justifications for them. And my prediction, as long as we're in the prediction game here, is we're going to get another decision that goes back to the Obama administration rules on Section 7. You all may remember the Facebook cases, where if somebody likes a Facebook post, all of a sudden it becomes concerted activity, even if the Facebook has nothing to do with the workplace. So that's what we're going back to, I think, in the very near future.
If I recall, go ahead.
I apologize. And I would add, Tyler, that I think the reason, and Tom, you made a really good point in flagging whether the pendulum is swinging faster than anticipated. I would add that that's partially a result of the fact that really, the biggest thing that a newly incoming president can do to shift the landscape is to shift the board towards a pro-labor or not pro-labor majority. And President Biden managed to push through that change somewhat faster than anticipated. He was able to have the Senate confirm 2 veteran union lawyer new members to the board within months of his presidency, which is with the start of his presidency, which is something that President Obama, for example, was not able to accomplish that quickly. So we're talking about a situation where the board shifted to a 3-2 pro-labor majority very early on in his tendency as president, not to mention the appointment of the general counsel that he chose to appoint. So we are going to be seeing, I think I agree with Tyler completely, a situation where we're swinging back to, a posture that kind of went away in the last few years. This whole notion of what it takes to find that a facially neutral policy violates Section 7 rights is probably the best example. Because what we're talking about here, and just as a reminder to everyone, the whole idea of Section 7 rights is that employees, unionized or non-unionized, have the right to engage in protected concerted activity, in activity for the betterment of their conditions of employment. And obvious, I think it's fairly obvious to everyone that a policy that expressly says you can't self-advocate, you can't advocate for better work conditions would violate Section 7. The bigger issue is, what about a facially neutral policy that doesn't on its own say you can't advocate for betterment of your conditions? When does that violate Section 7? And before President Trump's administration, it was a very broad pro-employee standard. The standard was basically was if a new facially neutral policy can be reasonably construed to impinge on Section 7 rights. And that could be a social media policy. That could be a policy about no cameras in the workplace. That could be a workplace conduct, don't be rude type policy. That's a violation. During President Trump's administration, that standard became a lot more employer friendly and basically said, look, if this is a facially neutral policy, like a social media policy that applies across the board, it's going to be okay if the employer's legitimate business interests for maintaining the rule outweigh its potential impact on protected concerted activity. So that's a much more friendly test that went into effect in 2017 with a case involving Boeing. Now we seem to be swinging back, exactly as Tyler mentioned, to the old reasonably construed standard, which really is going to put a lot of impact on employers being able to maintain broad policies about behavior and behavior in the workplace, social media, the whole notion of being polite and courteous in day to day, confidentiality, non-disparagement. It really is going to impact significant portions of employer policy.
Olga, thanks so much for that wonderful way in which you framed up the issue and the way in which we're going to look at how we're going to craft our policies in the future and how the National Labor Relations Board is going to review them. We're going to push pause here, and we're going to rejoin this conversation in a week or two on the Labor Law Insider podcast. And there we're going to tackle some of the wonderful, specific, and practical advice that we're going to offer our clients and friends as to how they ought to review their policies, which policies are at risk for potentially being improper, even though just weeks, months, or no more than a couple of years earlier, they were perfectly right in the middle of that which we found acceptable as policies. So stay tuned, everybody. Please join us again, Tyler and Olga, and we'll move forward with our Labor Law Insider podcast, part 2 of the changing scene of policies and given the National Labor Relations Board's changing world. Thank you so much for joining us.